Rhodes-Vivour, who is a British chevening scholar and is the managing partner of her own firm, Adedoyin Rhodes-Vivour Co., legal practitioners and arbitrators. She is also a chartered arbitrator and fellow of the Chartered Institute of Arbitrators. Mrs. Rhodes-Vivour graduated in 1980 and was called to the Nigerian bar in 1981. She is a notary public of Nigeria. She is a member of the International Chamber of Commerce, the International Court of Arbitration. She's the chairperson of the Chartered Institute of Arbitrators Nigerian branch. She is a member of the International Law Association International Committee on International Commercial Arbitration and the Pioneer Chair Committee on International Commercial Arbitration of the International Law Association Nigerian branch. She's also a member of the Arbitral Women and the International Steering Committee of the Equal Representation in International Arbitration Pledge. There is so much to talk about her. She has held significant roles in various international and domestic arbitral organizations, including being a member of the Permanent Court of International Arbitration. She also was a member of the ICC Commission Arbitration and ADR in Paris from 2011 to 2018. She was the Vice Chairman, Board of Governors, Lagos Chamber of Commerce International Arbitration Center, and was also the pioneer president of the Maritime Arbitrators Associations of Nigeria. She has written several articles on international arbitration, and she regularly delivers papers at international and domestic conferences and training events. So about myself, I am Niyati Ahuja. I'm an associate with the International Arbitration Practice Group at Diamond McCarthy. Without further ado, I welcome you all to today's webinar. I will be reserving the last 15 minutes for your questions, and let's start the interview with Mrs. Rhodes-Vivour. So my first question is for
Niyati, thank you so much for the introduction. But I just need to mention that there's a bit of not so accurate information there, because I'm not the current chairman of the Chartered Institute. I'm the past chairperson of the Nigerian branch of the Chartered Institute, and I'm also a past member of the Permanent Court of Arbitration at The Hague. So I just thought I should correct those two information. But otherwise, thank you so much for your kind introduction.
Thank you for those corrections. I believe that's what I have received regarding your information about you. But there's, as much as I say that it's all too late.
Thank you.
So my first question to you would be, what have been the major influences in your life that led you to a career in international arbitration?
Thank you so much. When I look back, I think I was very lucky to be exposed to arbitration very early in my career. When I graduated from university and also attended the Nigerian Law School way back in 1980. I commenced my career in the Lagos State Ministry of Justice. And at that time, well, first of all, I worked in the criminal law department where I was prosecuting. And then I was moved from there to the commercial civil litigation first, which I found very, very interesting, but uninteresting at the same time. And I think it also contributed to my interest in arbitration because the cases just were not going on. The Nigerian court system at that time had not incorporated case management principle into its rules of court. The court system was rather slow. There have been much improvements now, but the cases just were not moving, and I was getting rather restless. So I asked to be moved to the commercial law department. And over there, I found that many of the contracts being entered into by the state government had arbitration clauses. At that time, they were pretty basic, because there wasn't that much understanding of arbitration as it is now. Luckily, it was also a time when there was a lot of capacity building going on to ensure that African countries can negotiate on the best terms with the developed world. Thankfully, the United Nations UNCTC on transnational corporations, was doing a lot of work in Africa. And I was also very lucky to be exposed to that training. So from that basic background, that basic understanding, it sounded something in me. I was interested. I wanted to know. We were being told of the advantages of arbitration over litigation. And the kind of person I am, I like traveling, I like meeting people. It gave me the opportunity to have an international flavored type of career. And since that interest, I ensured that I went on so many more training programs. In the 80s, I was attending the ICC training courses. They used to call them PIDA at that time, where you go through the conduct of an arbitration from beginning to the end. And ultimately, I did the C.Arb training courses and got my qualifications. And with my employers at that time too, by that time I'd left the Ministry of Justice and I was in a private company. I was also exposed to an ICC arbitration. So I think it was the early exposure to arbitration coupled with my interest, my career interest, that did it for me.
That's a very interesting career path. So as I understand, you started practicing about 40 years back. And what have been the major challenges or major difficulties in building a career in this field? And how did you overcome these challenges?
Yes, I have. I graduated in 1980. I'll say that the type of person I am, basically, I don't focus on challenges. I focus on what I want to do and strategize on the best way to go about it. So for me, I don't see the need, I don't see the requirement of studying, getting involved in the top arbitral institutions, reading to pass the courses, which are very, very, very tasking. Because I mean, I'm sure most people know the quality of training that comes out from the Charter Institute or all the various top arbitral institutions, the ICC, the LCIA. When you go for their programs, it's not child's play, but you come out with a lot of knowledge. I don't find that as challenging. And if it's in terms of the requirements, the qualifications, the requirement to be independent, impartial, to be a person of integrity, neither do I see that as a challenge either. So I'd say that with lots of hard work, the service, if you want to build up a career in this field, if you want to make yourself different, if you want people to get to know you, you've also got to be ready to serve. You've got to be ready for people to put a face to you. I mean, nobody's going to appoint you as an arbitrator when they don't know you. They want to know you. They want to know what you can bring to the table. Do you have ability in the area of the art of judging? Do you have the ability to be impartial, to be independent? Do you have ability to impose some sort of confidence when you enter into a room? I mean, I really don't see that as challenges. But when I look back, maybe at times you have to really also learn how to deal with parties, particularly parties who make tactical challenges that they know are not well founded. Maybe they know they have a bad case, they want to frustrate the proceedings. So they do attempt to try and frustrate the arbitrator. But if you know what you are doing, you are qualified, you will not be able to fall for those types of issues. And it's important for you to also always make sure that you have your records. Your records must always be up to date because you don't know where it's going to get to. When they make those tactical challenges and they go to the courts, they're going to write all sorts of spurious accusations in the so-called affidavits they filed before the courts. And by the time the courts look through the proceedings, the court is going to be able to decipher what is true and what is false. So once you keep that principle in mind, making sure that your proceedings are well conducted and that you have accurate records, it makes it easier to deal in the terrain.
That's very helpful life advice in general, I would say. So just to go into my next questions on arbitrator appointments, I would love to know, when was your first arbitrator appointment, and if you could tell us some details about the case.
Okay, maybe one other challenge that every aspiring arbitrator faces is, when will my first appointment come? But what I'll say is, be patient, keep on doing what you're doing. Before the first appointment comes, write articles, make yourself known, let your name sound the bell. So I went through all that period, and then was sometime in, I think it must have been in 1998, I got my first appointment. It was, as you know, arbitration is confidential. I'm not allowed to divulge names of parties or anything like that. But I got my first appointment. It was a dispute involving one of the major oil majors in Nigeria and a construction company in relation to some construction contracts. I believe that was my first appointment in 1998.
Okay. So diversity in arbitration, as you know, has become even more of a pressing issue than it has been. So what steps, in your opinion, have been the most beneficial in improving diversity in international arbitration? I know we still have a long way to go, but what have been the most beneficial steps so far, and what we should continue doing?
Okay. Niyati, I know you know that diversity involves various aspects of diversity. There's geographical, there's gender, disability, there's generational, so we have to look at it all as a whole, right? And I'm sure you also know the effects of lack of diversity and lack of inclusion in arbitration proceedings. It affects the legitimacy of it. People begin, when it's just like if you go somewhere and you are not allowed to enter, you're going to have the perception that something is going on there that they don't want you to be part of, and that the reason for that cannot be a good reason. So if diversity is not addressed in international arbitration, it's going to cause dissatisfaction in the system. Just like what's happened with investor state arbitration, and we saw a lot of countries putting out of the bilateral investment treaties because they felt they were not having a good deal in the outcome of the proceedings. Well, a lot of talk is now going on. When I first came into arbitration, I wasn't even aware there was anything like diversity. It's only now that there's a lot of talk about it that I realized that in those days when I used to go for arbitration conferences, and I used to go to a lot all over the world, London, Washington, Singapore, you name it, but I never felt there was an issue of diversity. And I'm sure that in that room, maybe there were about 2 or 3 women. But because people were not talking about it, here was I, a young lady, still trying to get into the field, it didn't occur to me. But now people are beginning to feel the effects of lack of diversity, and people are beginning to talk. So what I would say are the major steps that have been most beneficial. First and foremost is people are aware of it and people are talking. That's very, very important. And then you have a number of organizations that have brought it upon themselves to actually take active steps to address these issues. We have Arbitral Women that have devoted to promoting women in arbitration. They've done a lot of work. I'm a member of Arbitral Women. They've received awards, Global Arbitration Gala Awards. They've received them for the work they're doing. People are becoming more aware that there are women who are trained, women who are qualified in this field. We have the ERA pledge, the Equal Representation in Arbitration pledge, which is a call for action. I mean, we're now, in those days, I'm sure, when we go for conferences, maybe you have 4 or 5 speakers and there's hardly any woman. But because people are talking, personally, even when events are being held in Nigeria, and I notice I get a flyer, there's an event, and I'm not seeing any woman, I call up and I say, what's happening? You have a panel of 5 people and there's no woman. So people are becoming aware. You have African Promise, you have the Alliance for Equality in Dispute Resolution. So I think that's one of the key things. And then again, the arbitral institutions themselves have taken responsibility. They have taken responsibility. The ICC now has a full gender parity court. Same number of women, same number of men. Arbitral institutions are publishing their statistics. So from those statistics, we are able to see what's going on. Other initiatives, recently there was a new list published, because everybody's aware, there was a new list published of African arbitrators. with linkages to the USA, but other arbitrators were also included. I was included, a couple of Nigerian arbitrators were also included, just to raise awareness. And the initiator of that was Catherine Simpson and a lady called Nancy. And she keeps us informed all the time. She's told us how many hits have been made on her webpage, downloading that list. So people are aware. So that's great work. There was a time that Catherine came across a list. I think it was the center list. And she found that there were no women there as chair. And Catherine took that up as a project and sent a list of women who were qualified in that field. And she addressed the issue. So that's a major step. Talking about it, taking concrete action, taking concrete steps. And another move that has helped is the moves being made to ensure, because if you keep saying that there aren't enough women or there aren't enough young people, and you're not training them, there's no point, because we're not talking of appointing a diverse panel for the sake of appointing a diverse panel. We're talking about appointing a diverse panel where the members have the necessary qualifications. So, and there's a lot of capacity building going on in Africa. Emilia has been very instrumental in this SANC.Arb report, which normally indicates what's going on in the capacity building institutions. So people know where to go to get trained. And that has also helped a lot. So, and then we have other institutions also coming up. We have the AFAA, the host of this program. Their primary task is to promote the pool of available and qualified arbitrators in Africa, and to help them along, to give them the necessary exposure. Arbitration institutions are now publishing statistics of arbitrators who are appointed. So we can know, are you appointing only the men, or are you also appointing women? When there are panels, are you allowing women speakers, or they're only male speakers? People now know that there's a threshold. And if you don't comply with that threshold, people are aware. So everybody, I mean, all the key participants are trying to key in to ensure that necessary steps are taken to address diversity issues in arbitration. Or else, if we don't do that, arbitration will lose its legitimacy.
I completely agree with you, especially on the points of the requirement of arbitral institutions to be transparent about the arbitrator appointments, because that's how you know what's going wrong. And when you see the statistics, and if the numbers are not improving as much as the initiatives taken are being so full-fledged, then you see there is a problem. And I guess secondly, the thing about being aware, if you're not aware there's something wrong, you can't solve it. No, and like you mentioned, back in the day, you didn't even think that was a problem because nobody realized it. If you don't acknowledge it, yes. It's hard to solve a problem. Yes. So coming to my next question, it's on what are the recent initiatives being taken, or I understand there is the best arbitrator, African arbitrator list, and the list you mentioned of African arbitrators with any relation with the US. What are the challenges, do you think, which have been faced by lawyers from Africa in establishing themselves in this field, and what initiatives are being taken to help them establish themselves in the international arbitration field on a global level?
Well, as I told you, there are many institutions who are now focused on capacity building. There are many institutions that have also included mentoring the younger ones in their programs. And they receive support from a lot of institutions as well. But I have to mention something. There's only so much you can do to help somebody. I mean, when we were building up our careers, I don't think mentoring had received the kind of full-scale recognition of it being a critical component in building somebody's career. We were lucky. We had 1 or 2 or 3 role models, maybe from our places of work, who we were able to look at, who were able to guide us. But it didn't have the same type of threshold recognition that it has now, which is very good. So I think the younger ones now, if they'll only listen, there's a long way to go. They should realize, first and foremost, that their time will definitely come. And that even now, when there's still some older ones who are in front of them, there's still room for them. Because it's good to have a diverse panel. But at the same time, they have to help themselves. They've got to be willing to go through the hard work. They've got to be willing to serve. They should join arbitral institutions. They shouldn't join and just be a fixture in the room, but they should actively engage. They should write articles. I mean, I remember in those days, I mean, I'll stay in my office and I'll be there till about 11, 12 because I'm trying to conclude an article that I want to publish. So it didn't come on a platter of gold. And that's one thing they've got to realize. And when I was trying to get in, money was not my consideration. It was the willingness, the interest in learning and being able to get the recognition as somebody who is competent. Because nobody is going to give work to somebody who has not shown his or her competencies.
I completely agree with you again. So do you think the countries themselves, African countries, have they taken any capacity building initiatives for the existing arbitration practitioners or young and upcoming arbitration practitioners in Africa?
Whether the countries themselves, right? Well,
yes.
When you talk about the countries themselves, are you talking about institutions in the countries?
It could be institutions, the government, the educational institutions there. It starts right at the law school stage, so.
Well, it's a good thing you mentioned the law school. I remember when I was in law school, nobody told me anything about arbitration. When I was in university, nobody told me anything about arbitration. But right now, in most African countries, you're having mock arbitrations being conducted in the law school, in the universities. Most universities also have viable ADR and arbitration communities. Many of them have come to my office several times. I've had discussion with them, and so have a lot of my other colleagues done that. So, and then the arbitral institutions, the Chartered Institute of Arbitrators has a lot of training programs it conducts for young members. It has a vibrant young members group. Mm-hmm. Yesterday we had the webinar where I also spoke to them, and we have so many things going on. We have the Lagos Court of Arbitration that also has events for the younger ones, and I know that it happens all over Africa. So I'll say that Africa is rising. Africa is aware of what it needs to do, and they're going about it systematically to ensure that we engage the younger ones. Because if we don't engage them, we can't complain if we're not being appointed. You've got to be competent, you've got to have the training, you've got to have the capacity to be appointed. So I believe that there's a lot being done in the area of capacity building. And I believe that was also highlighted in the report of the School of Oriental and African Studies on capacity building in Africa.
So I understand. So what do you think needs to be done on a global level so that more parties, even if it's say Australian party, if they have any relation with any other country, the seat of arbitration is, for instance, London or anywhere else, how would you think these African law firms can get themselves on the map and get nominated to represent them in these arbitrations?
You're talking about African law firms representing parties in arbitration.
Yes. How can they get more opportunities?
Oh, first of all, even right now, there's a perception that even African law firms are not appointing African, that African parties are not appointing African law firms. There's even a perception that African parties are not appointing African arbitrators in international arbitration. So it's a perception that we also, first of all, have to deal with. I mean, if you are not recognized in your own continent, how do you expect somebody else to recognize you? So Africans, first of all, have to demolish that perception. They are qualified law firms, top-rate law firms. African counsels have appeared before me, and they are top-rate. They can compete with any international law firm anywhere in the world. Look for those type of law firms and involve them in arbitrations. That's the only way to go. It's only by that perception that the foreigners can begin to have, if you don't have confidence in yourself, you can't expect somebody else to have confidence in you. So we should start appointing African parties, African arbitrators. We should start appointing African counsel, and we have a number of them that are qualified. I mean, it's good for African law firms to also work with international law firms, as sometimes happen. That way, the expertise is also being developed. And as time goes on, once the perception is removed, it should be.
So what do you think are the major roadblocks or hurdles why these African parties themselves are not appointing African law firms? Is it a trust building? Is it a lack of trust at the moment because the African law firms don't reach out to them or don't advertise enough that they're qualified as well? What do you think is the major roadblock or hurdle?
Maybe it's difficult to break the perception of how it was 50 years ago, 60 years ago, when arbitration was associated with certain jurisdictions. It's always difficult to break perceptions.
Mm-hmm.
And implicit bias, you know what implicit bias, when a bias is in your mind, you don't even really know, deep down, you haven't really questioned yourself as to whether that bias is there. But it's implicit, it's there, and you don't really know. So we've all got to make ourselves more open to see what is happening around us and within our continent.
I agree, and I think the implicit bias point is also true for the diversity point, which people have now started at least thinking that they might have an implicit bias, which they were ignoring earlier while taking every step while making arbitrator appointment or while choosing the team which was going to represent the party to include women lawyers in the team, for sure. So moving to my next question is, like you mentioned, there have been certain jurisdictions which have always been associated with international arbitration because that's where the best practitioners were, or that's where it began, and that's where the international law firms started practicing international arbitration. So London, Paris, and Singapore, as well as New York, are amongst the top chosen seats of arbitration. What do you think are the issues which can be fixed in order to get parties to choose African countries as the seat of their arbitration? Is it technological or logistical issues that need to be fixed, or anything else that could be amended?
Well, you know, the traditional known seats of arbitration, first of all, I want to start that they didn't just get there in one day. They worked at it, and they realized what they needed to do. England is one of those seats, and it's regarded as having a very strong judiciary. And if Africa really wants to be accepted as seats of arbitration, they have to be focused on what needs to be done and go about it. New jurisdictions have come up, like Singapore that you mentioned. When Singapore was going to elevate its status as an arbitration seat, it also took certain steps. It amended its laws. For instance, one of the laws that Singapore ensured that they amended was the Legal Practitioners Act, as it affects people that can appear as counsel in international arbitration. Can a lawyer not registered in Singapore represent a party in an arbitration proceeding? They made it clear. There was no ambiguity about it. And they changed the laws that they needed to change. So commitment is one thing. And another thing is, how do we assess a country where parties would like to go and arbitrate? I think the C.Arb centenary principles is a good start. I'm sure you know about the C.Arb centenary principles that list the 7 steps for an effective and safe seat of arbitration. It talks about a strong and effective judiciary. It talks about infrastructure in the place of arbitration. Nobody wants to travel to a country where the roads are bad, where they don't have top-rate hotels, where the facilities aren't there. Security is also important. Nobody wants to go to a country that's not secure, that they'll be afraid of being kidnapped because they've gone for an arbitration. Then the legislative framework is also important. As you know that the law of the seat of arbitration is very important. And that is the law that governs the supervisory role of the court. So is the country a UCITRAL model law country? Then enforcement is equally important. You want to be able to enforce your arbitral award. So a country that's obviously signed on to the New York Convention will get higher marks than a country that hasn't. Then you have practitioners in the field, people who are qualified, people who are arbitrators, people who are good, people who are sound. Are they there? Is the support system there? Do you have transcribers? Do you have registrars? May I mention again the Charter Institute and the role it's playing in ensuring that we have a good list of people that can act as registrars. We do specialized registrar training, and we also promote registrar trainings being conducted by other international institutions. Then air travel connectivity. How easy is it to travel from one country to the other? When I first started in arbitration, I can't remember even saying it's very sad, but I must confess, I never went to any African country because it just wasn't there. But right now in Nigeria, we have Kenya Airlines, go straight to Kenya. We have Rwanda Air that goes to Rwanda. And I've used those airlines. I've gone to Kenya, I've gone to Rwanda. So that's also very important, the connectivity, the ability to be able to move from one place to the other. An arbitrator doesn't want to get stuck somewhere because he has to first of all go to Europe before he comes to Africa. And then choice of counsel in arbitration proceedings. Our lawyers have to be prepared to develop the best skills, internationally recognized skills in conducting arbitration proceedings. Arbitration is not a court litigation procedure. I always get very sad when I get counsels coming before me and acting as if they're in court. And I always let them know, we're not in court here. I say jokingly because you have to be civil. You have to be civil, you have to conduct, make them relax, but still let them know so that they can also go back and go and learn and know the difference between a court reference, a court litigation, and an arbitral reference. So I believe that if African countries can and the government also has a role.
Definitely.
In all those countries that develop themselves, the government had a positive role. The government had a role in Singapore, even Dubai. I remember some years back when Dubai was trying to reinvent itself as an arbitration hub. They took certain steps and the government supported them. I remember then they had when I was the president of the Maritime Arbitrators Association of Nigeria, they looked for experts all over the world and they invited us to Dubai for an international conference on arbitration. So government has to be prepared to do what it takes, provide the infrastructure, provide security, encourage. Legislature have to be ready to pass the appropriate amendments to any laws that need to be passed. If African countries are to develop themselves to viable and preferred seats of arbitration. And I believe that some African countries are already on the right step.
I agree, especially regarding the legislative part, and African countries are definitely evolving in their law and making it more easier for parties to choose African countries as seat of their arbitration, or just even for the enforcement of awards. It's easier than it was some years back. So let's talk about virtual hearings. I understand arbitration is a field which is constantly evolving, and that's something which is always, you're always on your toes, and that's something which has interested me. Do you foresee any radical changes in international arbitration in the future, especially now that most of the hearings have been forced to be conducted virtually?
Well, in the light of COVID-19 era, what I foresee is maybe more distance virtual hearings. Before COVID-19, I had been involved in virtual hearings, but it was not for the full proceedings. There was one case that a witness could not travel from, I think it was Zambia then, to London. So we took his evidence by video conferencing and everything went well. There's another case I had where the respondent was not attending the proceedings and we needed to cross-examine. We needed to have the claimant's witness cross-examined. And the claimant made a plea that if we were to request for a fiscal hearing, in all probability, the respondent's witness was not going to turn up, and that would be money thrown away again. So as the arbitrator, I made an order that the cross-examination would be virtually, and that was what we did. And of course, the witness didn't turn up. So money was saved. Can you just see the beauty of arbitration? That's so flexible, without any ado. But now with COVID-19, we're actually having hearings. Virtually, the whole thing. I've been involved in a virtual hearing some weeks back during COVID-19 that involved even visit to the local SAN C.Arb, and everything was done virtually. And it also went well. And for me, I think Africa has been, or the whole world, I think arbitration is one field where the world was ready for it, even before COVID happened. I think the world was ready. We have so many protocols that have been put in place. We have protocols on cybersecurity in arbitration. We have the dealers checklist. We have so many of them. And then even after COVID-19, institutions like the corporate institutions, which also included the Cairo Regional Center, they put out a joint statement of arbitration in the midst of COVID-19. Then even our African institutions have done well. The African Arbitration Academy, they released a protocol which has been very useful. And in fact, the virtual hearing agreement, the draft that was attached to that protocol was a draft that I used in my virtual hearing agreement. I adapted it, of course, because arbitrators have to realize that you don't just take drafts verbatim. You have to adapt drafts to suit what you want to use it for. I adapted it, but I used it. So I think the arbitration field has really been prepared. There's also the document that was released after the Seoul conference. I think the document was video conferencing in arbitration, cybersecurity in arbitration. Yes. So I think the arbitration world is very much ready for this new era of less in terms of physical, more in terms of virtual. And the beauty about it is that it makes arbitration less expensive, I think. Or what do you think?
Definitely, and greener, because you don't have to travel. You're saving on your air travel, and it also forces you to use electronic bundles and electronic platforms and save on paper, which everybody was using as hard copy in various bundles in physical hearings.
And those bundles can be huge.
I can
and then what do you do? Yeah, and after spending so much money on compiling them and the paper costs and everything, what do you do with them eventually? The parties either ask for them back, or you let them know that if they don't get asking for them back, you're going to destroy it. So I think we should just rise to the challenges. There's a good reason for everything, I think.
And I think the cybersecurity issues have been very well dealt with recently because of all these virtual hearings. Even court hearings have become virtual, and they require more, not as much as arbitration, but they still require confidentiality, and all those security concerns have been dealt with. Are there any other things that you think are going to change a lot in the future? For instance, there could be more third-party fundings, or as you mentioned about the investor-state relations, there's the investor court which might be developed, and parties have decided that the bilateral investment treaties or investment treaties have not been as effective, and they're recognizing or amending their treaties now. So are there any other changes that you think are going to happen in the future, which are going to be radically different from the past of arbitration?
Well, in terms of investor treaty, I think countries will just review the terms of the bilateral investment treaties that they've entered into. For instance, in Morocco, Nigeria, BIT, that there's a lot of focus now on corporate social responsibility and other factors that they were important, but they did not take as much focus as they should have taken. And also, I think this has been happening in some years past about having multi-tiered dispute resolution clauses. Instead of just jumping to arbitration, you have your mediation, you have your good office, you have your resolution by top executives of the organizations. I think we're going to see more of that. More change, and more changes in terms of the treaty clauses themselves, because people are getting more aware.
Yes, and a lot of countries which entered into these treaties and agreements back when there was not as much knowledge about these provisions and how they could be used against them. They're recognizing it and changing and amending their treaties. So my last question, actually, before we introduce our special guest today, is what would your advice be to young lawyers in international arbitration and women in international arbitration to make it in this field?
Well, first of all, I think be assured. Be sure that it's a field you want to get into, because there's a lot of hard work involved. There's a lot of commitment involved. Once you're sure that it's a field you want to get into and that you have the requisite skills, there's some basic natural skills you must have. You must know how to judge, the art of judging. And people have different strengths, so you must know your strength. So be aware of that, and then be ready to learn. Be ready to go on conferences, seminars, develop your skills to internationally recognized standards. And be ready to expose yourself. Join key arbitral organizations. Be ready to spend time on writing articles. You must expose yourself. Nobody is going to give somebody an appointment if they don't know the person. So you must be able to do this. Join institutions. And don't just be I'm a member. Let people know what you're doing. Be active in those organizations. And that way people get to know you. Write your articles, improve your CV consistently, improve yourself, stay focused, and don't give up. It's only a matter of time once you go about it the right way. And always remember that any award that you write determines, as far as I'm concerned, whether you're going to get any more. So every single award you write must be written with great care. The references you are involved in, you must conduct yourself properly at all times. Adhere to the principles of independence, impartiality, and integrity. And be civil. Be civil to the parties that come before you. I remember the last arbitration I did. At the end of the day, the lawyer, a very senior lawyer in Nigeria, a senior advocate of Nigeria, he commended the proceedings and he said this was the first arbitration proceeding that he had felt relaxed. You don't have to make people feel that they should be on tender toes because they are appearing before you. Relax, be calm with them. And I think basically those are useful tips that any young lawyer should adhere to. And buy your books, read your books. Read your books. And there's so many books now for different areas. So be active in organizations, write your articles, read your books, be vocal, be present, be physical, even if it's virtual.
Yes, no, it's changing. It's changing. The Zoom really helps everybody be there. And even right now, we have our participants and I'm being able to talk to you. It's a great platform. Even if everything is virtual, people can make their presence felt.
Yes.
So without much ado, I would like to now introduce our special guest, who is also a colleague of Mrs. Rhodes-Vivour. It's Mrs. Niyati Ahuja, who is an associate of the Chartered Institute of Arbitrators and an accredited mediator with the Lagos State Multi-Door Courthouse. She has participated in several domestic and international arbitration proceedings. She facilitates in arbitration, mediation, and negotiation trainings. I would request our host to please join her as a panelist on the platform.
I'm joining her. For some reason, she's not.
Really?
Yeah. Says she'll be rejoining. She's probably. She away.
Yeah, Iriti. They want Iriti. Okay.
Perhaps you can take a question from one of the question and answer sessions while we wait for her to join.
Of course. So I apologize for that. We'll wait for her to join. So this is an interesting question. With an increased activity of arbitration in Africa, what legislative measures would you recommend governments to take? It comes from the same point of what changes governments could do. And I believe you mentioned there could be legislative changes and the judiciary could be more arbitration friendly. But our question is from Olipa Sakala. Sorry, I can't hear you. I think you're muted, Mrs. Rhodes-Vivour.
No. Yeah.
I can hear you now. So
Okay.
the question was, do you need me to repeat the question?
Trying to join in as a panelist.
Doyen, did you see question number 2? That
Number 2, I'm coming.
Do you require me to repeat that question?
I've seen yeah.
So the question is, with an increased activity of arbitration in Africa, what legislative measures would you recommend governments to take?
Okay, thank you. Can you hear me?
Yes.
Well, first of all, I think governments should review the arbitration laws, all African governments, to ensure that it meets the required standards. First of all, is their law based on the institutional model law, the latest revisions? Is it based on OHAGA? Whatever it is, whichever is the relevant updated law, they should update their laws. Another thing that I think, in updating these laws, they should ensure that arbitral tribunals are accorded immunity. Because particularly in my jurisdiction, we're seeing a lot of cases where people are making tactical challenges to arbitration proceedings without any regard for the obligation to conduct their cases in a way that represents what happened. It seems as if they are more focused on winning their clients' cases by all means. And then they bring all kinds of tactical challenges. They even end up also making the arbitrator party to the dispute. So I think it's time for African jurisdictions to also ensure that their arbitration laws provide for immunity and that their laws are very much up to date.
Thank you. Thank you for your question, Olipa. And so my next question would be that seeing that everything is virtual now, what are your tips for networking in this virtual world? For young lawyers, of course.
What's the question?
So in this virtual world, what are your tips for networking?
Tips for networking in this virtual world. Well, even despite the fact that we're all working remotely, there are many webinars going on. That even still allows you to have a presence. There are many conferences going on. The Chartered Institute is having a conference in November in Nigeria, and I've seen invitations to a lot of other conferences. So the avenue for networking is not foreclosed. It's definitely not. And then also writing your articles. This is the perfect time for young aspiring arbitrators to take time and write their articles, get them published. Let people begin to recognize your name. So in my view, the virtual world we're in does not adversely affect our ability to network, given the type of activities that are even going on.
Mm-hmm. I completely agree, and seeing that all of us are working from home now, I think we have a little bit extra time because we save on commute and stuff like that. We are not traveling as much, so we can definitely attend more webinars, and there is no dearth of the webinars. So my next question is from Imutinian. Do you think arbitration is becoming a bit too expensive?
Have you joined?
I'm trying to join.
Oh my God.
I've been online since just now.
Please join. What's the problem? Is that what's the question, Niyati?
So the question is, do you think arbitration is becoming a bit too expensive?
Well, I think that issue has been on for a long time as regards whether arbitration is getting expensive or not. For some parties, right, you have to weigh what is at stake with the cost of the arbitration. You have to weigh that. And when what is at stake is a lot, then the issue of expense is not even important to those parties. They just want to have their dispute determined in a fair manner. And that's why it's important for me, for parties to structure their dispute resolution clause properly. There's some disputes that should not even go to arbitration at all. And that's where clauses like the multi-tiered dispute resolution clauses come in. You have negotiation between the parties and their top officials as the first step. You have mediation. You have good offices. You have even the dispute resolution boards. Arbitration can be expensive. There's no point us denying that fact. It can be expensive. So parties should learn to be able to adapt their dispute to suit their pocket. There was a program we had, there was a paper that was delivered in the Chartered Institute of Arbitrators on that, adapting your dispute to suit your pocket. It's not every time you have to go to arbitration. Have you tried to resolve your dispute amicably? Have you tried that? And then for the arbitral institutions, I think we should all look at the scale of fees and make sure that it meets international standards to ensure that any outrageous expenses are cut out. I think basically, even the arbitral institutions in Africa, I think their fees tend to be lower. And if a comprehensive survey is conducted, that should indicate whether that's the position or not. But I think alternative dispute resolution can be an aid to avoiding the costs of arbitration, realizing that arbitration can be expensive and that when a party is huge, when a claim is huge, then you cannot blame the arbitral system for the costs involved. I think that answers the question.
Mm-hmm. Yeah. I also think, just to add to that, when the claim is of a smaller amount, parties can definitely choose for expedited arbitrations, which would not prolong for a 2-year period, but would end in 6 months. And they would not end up spending as much for the court administration fees and for their legal fees. So I think the main advantage of arbitration is party autonomy. And they can design their disputes as they want to. They can choose the institution which fits their pockets, as Mrs. Rhodes-Vivour correctly mentioned. So it is becoming too expensive. It might become too expensive, but if your claim is large, it's definitely worth it, and it keeps it, confidentiality and party autonomy are the advantages that you might not receive in a court proceeding. We are still waiting for Mrs. Ireti, who's having some difficulties, some logistical difficulties in joining the webinar. I'm happy to take last 2 questions before we end the webinar. I'm going to ask you a question, Mrs. Rhodes-Vivour. You're on mute.
Yes, I think I'm fine now.
Yes, so I'm going to ask you a question. When you were, are there any tips or advice that you wish you had received when you were a young practitioner?
That's any tips or advice I wish I could have received. Really and truly, I cannot think of any that I wish
Yeah,
I could have
you
received.
learned it as you went along.
I learned it as I went along. I opened my eyes. I was very receptive to new things. And I was willing and I was able to learn from what's happening around me. So you've got to be conscious of what's going on around you.
I think you had all the good advices back then. That's why you don't have any which you wish you had. And you
Yes.
had... So we do have Mrs. Ireti Banjo, who I introduced. She has finally joined. You're still on mute. Could you remove your... Hi.
Yeah.
This is Mrs. Ireti Banjo, who is an associate, who is a colleague of Mrs. Rhodes-Vivour. We just have one question after so much difficulty, so I'm glad you could finally join. I just have one question for you before we end the webinar. Are there 3 practice tips that you have learned from working with Mrs. Rhodes-Vivour, or things that she does and you would like to assimilate in your own practice? Love to know your thoughts on that.
Okay, thank you very much. I apologize for joining in late. It was as a result of my network. Yes, I've learned so much from working with a seasoned arbitration practitioner, and it was difficult getting just these 3 tips. The first one I've learned from her, she's always aware of her obligations, her duties and powers as an arbitrator, and this has really helped her. The duty of confidentiality, the duty to remain impartial and to be fair to the parties. And what is the result of this? She has not had any issue of misconduct because she conducts herself properly in every arbitration she partakes in. Then also another thing I've learned from her, she pays attention to details. We could work on a letter like over 10 times. Check, 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 and recheck. So she has taught me to have eye for details, and I'm very thorough, and I've learned that from her. Another practical tip I could give, work hard. She has said it all. She works very, very hard. And she wants you to solve problems. Don't tell me about the problem, solve it. There is no challenge in her dictionary. Excellent work will make people appoint you over and over and over again. She's an excellent arbitrator, I must say. I've learned so much working with her. Thank you very much.
Thank you so much, Ireti. So as we come to an end of our webinar, I would like to thank Mrs. Rhodes-Vivour for taking the time out to be here and share with us her experiences, and for the great advice which we are going to keep in our minds after this webinar. Thank you to Mrs. Ireti for joining.
Thank you very much.
Of course. Thank you to the African Arbitration Association and Dr. Buruti for organizing this webinar, and all of you participants for joining. Thank you.
Can I just also thank Niyati? I hope that the conversation has been what you would have wanted it to be.
Definitely.
Yeah. Yes, and I want to also thank the Secretary General of the AFAA, who worked tirelessly to make this day happen, and the entire board and members of the AFAA. And then I'd like to thank Ireti for all the nice and kind words that she said about me. Thank you so much, and it's really been a pleasure meeting you, Niyati. And I wish you all the best of luck in your arbitration career. And very soon, I'm going to start hearing your name all over the place. Thank you.
Thank you so much. Thank you, and I hope everyone has a great day ahead.